We are so fortunate today Tom Phillips to have Jerry Lynch as our luncheon speaker. I think most of us know Jerry and know him very well. He's one of the finest judges in the federal system, super thoughtful. He was appointed to the district court by President Clinton, and then he was the first confirmed Court of Appeals judge nominated by President Obama. He continues to teach at Columbia University in the criminal law and other courses. Every time Jerry says virtually anything, I learn something important. Jerry, thank you so much for being with us here today to speak about the ALI in an age of skepticism. Jerry Lynch.
Well, thank you, David, for that introduction, which comes close to the perfect introduction, actually. Henry Monahan, one of my colleagues at Columbia, was in charge of the faculty lunches. And he would usually introduce a speaker by saying, and now here's a person who needs no introduction and therefore will receive none. But I'm honored to have been asked to address this gathering today in honor of those who've achieved significant landmarks in their membership. It's nice to think of achieving 25-year status, let alone 50, in the same year that the ALI itself turns 100. I was very honored to be elected to membership in the ALI 25 years ago. But there was one thing about the Institute that I wasn't that comfortable with right from the beginning, and even more so after I became a member of the council. My one reservation was that this organization seemed to be one of the most self-congratulatory bodies with which I've ever been associated. And I've been associated with law schools, the judiciary, the United States Attorney's Office for the Southern District of New York. I mean, I'm no slouch with organizations that are self-congratulatory. We're good at crediting the collective accomplishments of the ALI over the years, as well as the individual achievements of our members. Now, I was raised to think of humility as a virtue and to disapprove of bragging, so this made me a little uncomfortable. But after 25 years of sharing in the work of the Institute, I've become more comfortable with our efforts to pat ourselves on the back. The glory of the Institute is well earned, and the success of our work is the product of the preeminence of our membership. At the same time, it seemed to me that, in the midst of this celebration, it might be useful to have something a little bit more astringent. So here goes. I've had really 25 years of membership in the Institute, but effectively 50 years of being familiar with the Institute, going back to my first encounters with the restatements and the model penal code in my first year of law school. But I think we can't be too complacent in the era in which we now are. Perhaps today's law students still look at the restatements as pillars of legal learning, just as I did 50 years ago. They may simply take these volumes as if they came from the head of Zeus, fully formed, without much thought about where they actually came from. I suspect, though, that the reaction of current law students on eventually learning where they do come from is different than that of my generation. I was inclined to be all the more awed by the fact that these volumes were not merely shepherded into print by distinguished scholars like Wexler or Farnsworth, who served as reporters, but rather were the collective product of thinking by leading judges, scholars, and lawyers who vetted, improved, and approved the work of individual scholars who helmed the projects. I imagine that many of today's law students might pause at that. Rather than taking the distinction of the membership for granted, many today might raise an eyebrow at the creation of law reform texts by self-appointed, self-replicating elites. What one scholar says in a treatise can be agreed with or argued against, but the collective product of the legal establishment must be suspect to many. Significant changes in society and in the intellectual environment may mean that our production is more likely today than ever to be met with skepticism. Why is that? Some of it comes from the history of the institution. Listen to the names of some of the early leaders of the ALI and the founding members of what we've been hearing about and we'll hear more about in the next session, the Committee on the Establishment of a Permanent Organization for the Improvement of Law. It was organized by William Draper Lewis, Dean of the University of Pennsylvania Law School, later founding director of the Institute. The first president was George Woodward Wickersham. That's Cadwallader, Wickersham, and Taft. You can't think of a waspier name for a law firm than that. Other members, Chief Justice and former president. Now there's a resume. William Howard Taft. Future Chief Justice Charles Evans Hughes. They all had three names. Because they had to get both families from the Mayflower into their name. Former Secretary of State Elihu Root. These were definitely names to conjure with. These were men, all men, of course, who were confident of their stature, not just in the legal profession, but in their role in American society. Today, you don't have to be a card-carrying member of the woke mob. Do they issue cards? Do they issue membership cards? The mobs usually don't. You don't have to be a card-carrying member of the woke mob to note that these were all men. They were, of course, all white. They were indeed all Protestant. If you go to the exhibit on the ALI history across the street, which I urge you to do, it is very impressive indeed, but look at that first picture of all the members. I can't say there's no dark face in, but I'm betting there wasn't, and I didn't identify one. They were nearly all men. I think, pick out a couple of women in the crowd, but only a couple. The self-confidence of the establishment of that day came in no small measure from the fact that, however much they might disagree with each other over particular points of law, the most prestigious members of the legal establishment came from a rather narrow social stratum. Indeed, if you think of the law firms, at least in New York, that those men came from, I know that as late as the 1960s, there were firms of which some of these people were the founders, that did not admit Jews or Catholics to membership in the firm. African Americans, I don't think they excluded them. They didn't even think that was a possibility, so they didn't need to. Asian Americans, they thought about excluding them from the country, not just from the law firms. Moreover, in creating the first restatements, the principal work product of the ALI in those years, they were seeking to regularize and improve a body primarily of common law, which had been created by judges, not by politicians. In other words, they were reviewing the work product of other men, rather like themselves in background, education, and social class, and the work that they created was then addressed to those same men in their capacity as judges. When the Institute later did address itself to legislators, as with the Uniform Commercial Code or the Model Penal Code, the membership of the Institute still spoke with a singular authority. Now, over the years, the membership of the organization and its leadership expanded. In the wake of the New Deal, it came to include more and more academics, a body increasingly liberal, incorporating Jewish and occasionally Catholic as well as Protestant lawyers, but they still spoke with the voice of the establishment on topics that continued to be seen as technical matters for legal experts, as strange as that might seem today. Perhaps this is the parochial view of one whose primary area of teaching and practice has been criminal law. But it seems to me that the high watermark of the Institute's influence was the Model Penal Code of the early 1960s. It was actually a product mainly of the 1950s, to create, we work slow, but finally promulgated in 1962 or 1963. From its final approval by the Institute through the mid-1970s, 2/3 of the American states, through their legislatures, adopted new criminal codes, modeled to a greater or lesser extent on Wexler's great project. But the winds were already shifting by the 1970s, and criminal law is a good example of how they shifted. As the Model Penal Code wound its way through the legislatures, its form, the most technical part of it in a way, was influential. Some of its solutions to specific problems were less so, as legislatures questioned things like the absence of prohibition on homosexual acts. The last gasp of penal code reform, undertaken with great fanfare, was the effort to create a model penal code-based reform of the utterly chaotic federal criminal code, which was in the 1970s and remains to this day nothing like a code. It's just a random collection of statutes, old and new, some of them going back to 1789 in the first Congress, some of them adopted yesterday, many of them written with crayon. A commission under the former California Governor Edmund G. Brown, that's Edmund G. Brown the first, Pat Brown, not Edmund G. Brown, Jerry Brown the second. The commission its staff was headed by Wexler's associate reporter, Louis Schwartz of the University of Pennsylvania. And notice, Jewish names starting to get into the mix. They developed a draft that was introduced in the Senate as S1. And in the wake of the leaking of the Pentagon Papers, all of the technical improvements suggested by the commission got lost in a left versus right political battle over official secrets laws. And the entire project went down to defeat, never to be seriously revived. So what happened? At the micro level of the criminal code project, even as the model penal code was at its peak of influence, the subject of crime stopped being a matter for philosophers and legal scholars and became a highly contested political battlefield. But that was just one symptom of an overarching change in thinking about law and politics. Skepticism of expertise became fashionable, not without reason. See the Vietnam War. It was experts who got us into that one. After all, wasn't the subject of crime and punishment inherently political? For that matter, law professors began to argue that wasn't all of law a cover for the power of that very narrow establishment that produced the products of the ALI. Much of that criticism in the 1960s and 70s came from the left, which was very fond of pointing to the demographics of the ALI of that era and even more so the earlier era. But also, coming from the left were broadly devised theories that undertook to see through the pretense of rational thought to the underlying role of law in protecting the established order. If you thought that order was unjust, then the objective principles of the law began to look unjust as well. At the same time, law was changing. Some of the very experts who joined the ALI, even from the very beginning, were also prominent supporters in due course of the New Deal and the resulting administrative state. One consequence was the rise of legislation and administrative regulation as sources of law. The great common law fields that were the grist of the great restatements and that were at the heart of the principles that the MPC sought to introduce into legislation and codify were shrinking in importance compared to policy-driven, politically enacted statutes. Whether you liked or disliked the particular policies, it was difficult to see them as the product of lawyers' unique skills. They respected policy notions, sometimes driven by technocratic expertise of scientists or economists, but ultimately winning and losing in the political more than in the judicial arena. Well, how has all of this affected the ALI? Well, one very good effect has been the demographic broadening of the membership. The great WASP establishment crashed and burned. The patriarchy was dented. Women, Jews, Catholics, African Americans became part of the legal establishment, as did members of other minority groups, including the children of East and South Asian immigrants who were barely visible in my law school class, but now form a significant part of the rising most successful law students and are joining the ranks of major law firms, the academy, the judiciary. We in the ALI are no longer a narrow swath of society, at least in those respects. But at the same time, however demographically diverse, the elites remain the elites. The very markers of accomplishment that verify our claim to expertise tends to make others wary. Today, the elites themselves are no longer as coherent as in the days of Wickersham and his colleagues. Now, much of the criticism of the ALI comes from the right in its own populist branch, but also in the area of economic elites. But the complaint is not that different. Who are these self-appointed members of an intellectual elite to tell anyone what the law should be? Moreover, the legal profession itself has changed. Specialization has undermined some of the claims to generalist legal skills that ALI members once boasted of. And the specialization is not just by fields of law, although that is very important. It extends as well to which side of the V litigators tend to have as clients. This affects the ALI in its work. We commit ourselves to objectivity, to leaving our clients at the door. And I think the overwhelming majority of our members believe in and practice that ideal as best they can. But if you spend your professional life representing insurers or accident victims, but not both, representing creative artists or rights holders in intellectual property, the state or criminal defendants or crime victims, it is much harder to leave your clients at the door, not because you're trying to advance the narrow interests of people you represent or to win more cases, but because your mental apparatus, like all of our mental apparatuses, is largely shaped by your experience on one side of persistently divisive issues. If you think about yesterday's debate, I think the hottest one we've had, conducted with typical civility and intellectual rigor by the membership. I'm not criticizing it. The one about medical monitoring causes of action. Many of the people who spoke, and I think appropriately so, referenced their experience as regular participants in litigation on behalf either of insurers or of plaintiffs. How could they not? How could they not draw on that experience? So yes, you can leave your clients at the door in terms of trying to give your best view of what is objectively right or best for society, but that is inevitably shaped by experience. Similarly, as we achieve a more representative membership in the Institute, in the Council, that leads to more division. Because more people come from different backgrounds, having different experiences of what the law is, and our internal work becomes more difficult. So here are some of our challenges as we enter a second century. I think the restatements remain a bulwark. That is where we are at our best strength and where we have our greatest influence. But more and more of our work necessarily addresses legislatures and other decision makers as we turn to principles projects and model legislation to bring our wisdom, such as it is, to bear on areas of law that are not primarily made by judges. I fear that in many of those areas, the clearly political issues are close to the surface, and the policy choices are at the forefront. As we saw yesterday, even when we're dealing with common law subjects, particularly ones where the courts are divided, whether it's a third, or as someone said, a half, whatever the actual division, it's hard not to think that we all, in voting, ultimately we're relying pretty heavily on our priors, on our kinds of commitments to what we think justice ought to look like, where we don't necessarily have the empirical base of information to make a fully informed judgment about those policies. Now, that work can still be influential, but the influence may not be as easily measured as citations of the restatements in judicial opinions. We have revisited outdated portions of the model penal code in the area of sentencing, sexual assault, and the death penalty. By the way, I have to claim some responsibility. I was pushing Lance, we could do sexual assault, we could do sentencing. Things have changed a lot since the MPC, and there's already a body of stuff out there. There are scholars who come with ready-made model statutes. This should be an easy ones. Well, those projects were both more contentious within the Institute, and it's fair to say, I think, less influential without than the original model penal code. As I mentioned before, the establishment itself has split into different factions. And just as the legal establishment at the founding of the ALI tended to be a comfortable conservatism, reflecting the values of a social and economic elite, although always with a slightly progressive tinge. It was a law reform organization, after all, from the start. But today, the more academically tinged legal establishment tends to reflect the values of a more demographically diverse, but more ideologically center-left to left intellectual elite. Formally excluded groups and populist insurgents have little use for either kind of establishment and see political power as the defining goal, with not much patience for the technical concerns of philosophy or law. We've come to see well-funded attacks on the ALI by interest groups concerned that we're going to come out on the wrong side from their vantage of issues, and therefore we should be discredited. These are serious challenges. I think probably in about 5 or so years, we should probably be taking a good look at some of the principles projects and seeing what influence they have or have not actually had as a way of thinking about whether that continues to be a good use of our time. But one way or the other, I think we necessarily have to reconcile ourselves to less immediate influence than the ALI once had in the days of a more coherent and constricted establishment. We may have to become used to being one voice among many, competing in the legal marketplace of ideas. Now, is that a cause for pessimism? Well, I guess if you like having power and influence, it is. You want to have your ideas get adopted into law. It's nice to be able to say, hey, look, we're the guys who know, and so yield to our greater wisdom. It's harder to be one voice among many, having to earn your way with competing academics, politicians, ideas that show up on social media, chatbots, and God knows what else. But at the same time, we are a more diverse group in that we represent the society better than we once did. We do engage in dialogue and discussion. We do honor the craft of lawyers and judges. We produce work that, however much it inevitably reflects policy choices and a certain kind of centrist, maybe a little bit liberal establishment thinking, it attempts to engage with ideas from all corners of the legal world. And we strive and often succeed, if only because of the painstaking and time-consuming processes of arriving at consensus approval within the organization. We strive to avoid the tabloid headlines and political fads of the day. The nation may not always know it or believe it, but it continues to need organizations that provide that kind of advice. The influence is going to be there, I think. It's going to come from the quality of the ideas, but it will be perhaps less immediate, less obvious, less conclusive. We continue to elect new members. I'm afraid very few of us in this room will be here to see this year's crop of new members at their life member luncheon. I hope that they will have as much good work to look back on and will take as much pleasure in the effort as those of us who've lived through the last, I will say, half century of the ALI's history. The challenges continue, and I'm sure the Institute will continue to do its very best to grapple with them. So thank you very much. I was told 10 to 15 minutes. I think I got close. I am not a man of few words. Thank you.
Thank you, Jerry. That was really great, and gave us something to think about and talk about. Roberta and I fully intend to be here in 25 years, so we'll be able to report back to you on how the new members have accommodated. The Institute keeps changing, and many of the themes that you hit on are ones to continue to think about, and we hear this in the debates that we have. I think you hit on a lot of those themes, and thank you for that very thoughtful presentation, and thank all of you for your 25 years of service and your life members. But that means, I think it means that we don't charge you dues, but otherwise, we really want you to continue to participate, and if you feel like paying your dues, that would be good too. So thank you very much.